Okay, I found an old copy, The Rules of Professional Conduct from 1990. Someone accused me of being searching the internet or being an internet lawyer. No, I've been doing this for a long time. I don't even know if there was 1990. I think there was what, AOL maybe, or dial-up. I haven't had access to the internet all that long. But this is out of a book. I copied it off the old school way, office printer, scanner, whatever. But I copied this out of a book. It says, practice of laws of public trust, lawyers, the trustees of the system by which citizens resolve disputes among themselves, punish and deter crime, and determine their relative rights and responsibilities, ties towards each other and their government. Lawyers, therefore, are responsible for the character, competence, and integrity of the persons who they assist in joining their profession, for assuring access to the system through availability of competent legal counsel, for maintaining public confidence in the system of justice by acting competently and with loyalty to the best interests of their clients, by working to improve that system to meet the challenges of a rapidly changing society, and by defending the integrity of the judicial system against those who would corrupt, abuse, or defraud it. And so once you get in the rules of professional conduct, into the rules, not just the preamble, you'll find that they're not abiding by it. But anyways, my whole point was that the more I use the rules throughout the years, they consistently change it. I was looking for my copy of the rules from the revision from 1979. In the opening of the preamble, it said something similar, but it also mentioned that violating the rules of professional conduct is violating the Sixth Amendment of the U.S. Constitution, which is effective assistance of counsel, which unequivocally makes anybody ineffective assistance of counsel for violating the rules of professional conduct. There's supposed to be zero tolerance on violating the rules of professional conduct, but they tolerate any violations of the rules and the codes. And any violation of the rules of the codes is mandatory to report. That's misconduct. So any violation is misconduct, and reporting misconduct is mandatory. Failure to report that misconduct is misconduct. Nobody reports that misconduct, which creates conspiracy against rights under color of law, which any lawyer violating the rules of professional conduct is deprivation of rights. That's violation of federal law. Okay, so remember, there's supposed to be zero tolerance, but there isn't. It's not my fault. People quit getting angry with me because nobody's living up to the oath. Nobody's enforcing the oath. Nobody's living up to the obligations of the oath. And I keep posting all these videos of me reading laws to you that nobody's doing. It's not my fault that nobody's doing this. I've been trying for years. I've been throwing things at them since the 80s, the beginning of the 80s. But like I said, hopefully I find that revision from 1979, and that way it'll make it as easy as it was on me when I first read the rules of professional conduct back in '79, where it clearly stated that violating the rules of professional conduct is ineffective assistance of counsel, which is violating your constitutional right to effective assistance of counsel stated in the Sixth Amendment of the United States Constitution. People say it's not that easy, it's difficult, it's complicated to prove ineffective assistance of counsel. Not if you use the rules. All this is supposed to be happening at the very beginning, from the very start. So since this didn't happen at the start, anything beyond that is frivolous litigation. It's nothing more than legal harassment to get you to settle for what they were throwing at you in the very beginning, which was under the color of law. Conspiracy against rights under the color of law. They just want you to accept it. But even still, even though you do, if you take a plea deal, you can file an effective assistance of counsel petition and state the violations of the rules of professional conduct and the violations of the Code of Judicial Conduct. You not only want to cite your lawyer for ineffective assistance of counsel, but the opposing party for multiple violations as well, and the judge for judicial misconduct for not reporting that misconduct. Okay, people, but this is a old version I found. If you want, I was thinking about scanning it and putting it on the net for you to show you how much it's changed. But it keeps changing because I've been telling people for years I use their words against them. My play with words is using their words against them, word for word to the letter, and showing that they're not doing this. It's easy to prove that they didn't do this. It's hard for them to prove that they did. Okay, so that's what makes it simple. Nobody can prove. If you read the rules of professional conduct, you'll see there's a lot of do's that ain't being done and a lot of don'ts that are being done. They cannot prove that they abided by the rules of professional conduct or the Code of Judicial Conduct. And since this didn't happen in the very beginning, anything beyond that is frivolous litigation. That's actually contempt of court. Deprivation of rights, conspiracy against rights under the color of law, all constitutional violations. U.S. constitutional violations. And remember, anything repugnant to the United States Constitution carries no weight. It's null and void. Okay? Nothing but peace and love to you. May your Creator always be with you and rain many blessings. I wish you a long life and good health. Thank you for listening.